moments from a very long interview that covered a lot of different topics, and I'm going to link to the full thing down below so you can watch it. With that said, whether you've watched the full thing or given what you've seen here, I gotta ask you, what are your thoughts and reactions to this whole situation? But then switching gears from that to other news, we need to talk about how a brain-dead woman who was kept alive for months, not to save her, but to avoid breaking Georgia's abortion law, just gave birth, if you can even call it that. This is the Adriana Smith situation that we talked about a few weeks ago. And the quick breakdown here is that Smith worked as a nurse at Emory University Hospital, and she had to be admitted back in February, which is when doctors discovered blood clots in her brain. But then shortly afterwards, being brain dead, and her family wanted to take her off life support, considering that she had no hope of recovery. The staff at Emory University Hospital, they wouldn't allow it because Smith was 8 weeks pregnant, and they were scared that in a roundabout way, they could be accused of causing an abortion by removing her from life support. Because Georgia's law, it bans all abortions if any cardiac activity is detected, which can be as early as 6 weeks. Which, as we've talked about, it's so early that many women may not even realize that they're pregnant. And so this entire situation, it was seen as a prime example of how anti-abortion laws often have tragic and unforeseen consequences. With then all of that bringing us to Friday, where you had Chance being brought into the world via C-section and coming in at just 1 pound 13 ounces, which is extremely small for a baby, even a premature one, and Chance is now in the neonatal intensive care unit. Though fortunately, at least according to his grandmother,
and he's expected to be okay. He's just fighting. We just want prayers for him. Just keep praying for him. He's here now.
Right, and as you can imagine, this is a bittersweet moment for her because after Chance's birth, she spoke to the hospital about removing Smith's life support, all of which then led her to say,
"It's kind of hard. It's hard to process me burying my daughter. My daughter, she buried me."
Now with all this, one of the things we don't know is why Emory decided to deliver the baby at this specific moment. But one possible reason is that they wanted to strike a balance between removing Smith from life support as soon as possible in accordance with her family's wishes, while also avoiding Georgia's anti-abortion law. So as soon as her baby was potentially viable, they did the C-section. But also, understandably right now, the hospital isn't saying much. And that is, it's also not like Smith's family has much love for the hospital following them allegedly bungling Smith's diagnosis. Because she had initially gone to the hospital due to headaches and then was sent home before needing to return the next day, with Smith's mother saying,
"Oh, she would say that they failed her. She would definitely say that, Mommy, they failed me. If the shoe was on the other foot, I would have been there and I would have made recommendations."
While women, and especially Black women, getting their health concerns ignored is unfortunately nothing new. We've done deep dives on the topic. That entire conversation, it's being overshadowed by the debate surrounding Georgia's abortion law, with the law itself being fairly vague about what to do in a situation like this, which is what makes Emory so extremely cautious. But also, you have Georgia officials claiming it wasn't even necessary in this case, with State Attorney General Chris Carr saying back in May that removing Smith's support wasn't against the law.
Introduction. In the latest flurry of motions, plaintiff filed. She now improperly seeks Lance Bonnell, that's me, and prevent him from publicly defending himself or even talking about the lawsuit. While seeking the extraordinary relief of prior restraint of Bonnell's First Amendment rights, plaintiff herself continues to attack and malign Bonnell online, including through her Substack posts, social media updates, pleas for additional witnesses to come forward, and solicitations for donations to her legal fund, all of which have been viewed collectively more than 1.5 million times. Rather than preserve fairness, as plaintiff claims to be her goal, her proposed order would ensure just the opposite. In short, plaintiff seeks to draw and benefit from public assistance while pursuing her lawsuit anonymously and muzzling the defendant at the same time. Such extraordinary relief is neither warranted nor supported by law. Plaintiff's motion should be denied. Wow, true. What an absolutely true and based argument. Plaintiffs online, were these ones that were sealed before? No. I don't know if we read these on stream or not, but they're trying to, I think they filed a motion to the court for basically a confidential, like a gag order. They want us that I can't ever talk about my case publicly, or I can't go over any of the filings publicly, is what their goal is. So whatever. Plaintiff's online smear campaign began even before she filed her lawsuit and continues to this day. On January 20th, 2025, plaintiff published an article on Substack titled, "I Will Be Suing Stephen Kenneth Bonnell II." That full, she got it all in there. Wherein she falsely accused Bonnell of intentionally distributing pornographic content featuring plaintiff and using a proxy to widely distribute that content. Plaintiff's Substack post is still active. Plaintiff also used her social media accounts to advertise and promote her Substack post, including on X and Blue Sky Social, in which she wrote, "I will be suing Destiny in federal court. Here's my story," and provided a link to her Substack post. Shortly thereafter, plaintiff and her friend, Lauren Dreben Hayden, created a Give Send Go page, similar to a GoFundMe page, to raise money to cover plaintiff's legal fees. In this case, the Give Send Go page includes a link to plaintiff's Substack post. In addition to her Substack and Give Send Go pages, Plaintiff has posted and continues to post messages online, including on X, using the handle @PixieLove, about Bonnell, the undersigned attorneys, and the allegations in her lawsuit. Her public statements include vitriolic attacks on Bonnell and his attorneys, regular updates concerning the rulings of this court, repeated pleas for money to fund her litigation, as well as renewed pleas for additional witnesses to come forward and testify against Bonnell. For months, plaintiff has repeatedly and publicly accused Bonnell of twisting the narrative, has encouraged potential witnesses to come forward and testify against Bonnell with a promise of anonymity, and has continuously solicited monetary donations for her purported legal fund. For example, on May 19th, 2025, plaintiff posted on X, "Please don't hesitate to contact me if you believe you might be a witness or another victim." Then, just a few weeks ago, plaintiff posted the following on X. "Good news, despite opposition from Destiny's counsel," sick, "the court has granted us the ability to keep witnesses," sick, "identity under seal. If you have any information regarding the case, we can file to keep your name out of public and protected by the court. Please don't hesitate to contact me if you believe you might be a witness or another victim." Oh no. Also, please help and donate if you can to help keep the case going. Every dollar counts. Plaintiff further attacked Bonnell for allegedly playing into the humiliation/defamation/public harassment campaign that's being used to scare other victims into silence. Oh, over the Dunhams thing. Further, on May 20th, 2025, plaintiff published Bonnell's legal filings on X, publicly rebuked him, and commented on the legal issues for the court. "I suggest you reread the objection your legal counsel filed. Destiny's claiming his only issue is not having access to the redacted documents. This is extremely interesting. Destiny's attorneys were told repeatedly they would have access to the unredacted versions. That's not true. Giving them access to the names for the court could protect them, would defeat the purpose of the seal. That's also not true, but okay. Prior restraints constitute one of the most extraordinary remedies known to our jurisprudence and are universally recognized to be the most serious and least tolerable infringement on First Amendment rights. The First Amendment informs us that the damage resulting from a prior restraint, even a prior restraint of the shortest duration, is extraordinarily grave. While courts have adopted varying standards to evaluate restraint, this is boring, I think. Just like you probably shouldn't be able to do First Amendment stuff, or you need a pretty high bar to muzzle somebody. Where litigation remains in its early pre-discovery posture, as here, courts are markedly reluctant to curtail speech, limiting speech by parties and witnesses, particularly in a civil case, and at such an early stage as not to be taken lightly, or is not to be lightly undertaken, rejecting claims that early stage commentary created a likelihood of material prejudice and denying requests for sanctions or restraint where no discovery had begun, no trial date had been set. Prior restraints are permissible only in the most exceptional circumstances where speech imperils other rights, blah, blah, blah. The movement must demonstrate actual conduct that threatens to interfere with the judicial process, not speculative harm or generalized discomfort. Here, plaintiff fails to, if you had to pick a number, what percentage of things they mention is actually relevant for this case? I unironically have forgotten what the actual laws are in contention. In my opinion, I think that most of this lawsuit is just her doing as much, like shoving as much random to basically try to destroy me in filings as possible. I think she's given up on the actual lawsuit itself, and now they're just trying to waste my time and money and tank my reputation. Courts have consistently rejected efforts to justify speech restriction, blah, blah, blah. Here, plaintiff has made no attempt to identify which, if any, specific statements from Bonnell purportedly caused her harm, nor has she articulated how any of those statements pose a concrete risk to the fairness of trial proceedings. Plaintiff's motion lists a range of grievances, alleged harassment, mischaracterization of filings, speculative commentary about witnesses, but fails to connect any of those assertions to specific statements that risk material prejudice to these proceedings. Mere recitations of harm without evidence or linkage to particular content fall well short of justifying a constitutional restraint. Plaintiff's assertion that unnamed and or yet unidentified witnesses may be deterred due to online harassment or exposure is exactly the sort of vague, unsubstantiated claim courts reject. Plaintiff's dissatisfaction with the content of Bonnell's alleged commentary online does not change that result. Plaintiff alleges that Bonnell's public commentary is misleading or misrepresentative. Even assuming her allegations are true, plaintiff fails to meet the exacting constitutional standard for the imposition of a prior restraint. Indeed, even inaccurate or adverse commentary remains protected speech. Plaintiff's allegations are speculative, or evidentiary standards are non-existent, blah, 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 blah. I don't think anything else interesting is in here. Would be interested to hear what their strategy is for winning the case. Given they're still asking publicly for money, surely distorting financially does not justify publicly raising money under the pretense of justice. I mean, she'll never publish or post like what the money was spent on or what her legal fees were. Like, that'll never be made public. If they're even charging her at all, who knows? There is a section about doe filing in a shitty way. Wait, is there? Plaintiff's ongoing publicity campaign undermines her claim of prejudice. Courts have emphasized that gag orders must apply even-handedly and that a party's own public statements can undercut any claim of one-sided prejudice. Rationale applies with even greater force here, where plaintiff has chosen to litigate publicly via Substack, GiveSendGo, and social media while attempting to bar Bonnell from doing the same. Allowing one party to broadcast their message and then invoking fairness to silence the other undermines core First Amendment protections. As stated herein, plaintiff's online smear campaign began even before she filed her lawsuit and continues to this day. In addition to maintaining a Substack and GiveSendGo fundraiser, plaintiff has posted and continues to post messages online, including on X, about Bonnell, the undersigned attorneys, and the allegations in her lawsuit. Blah, blah, blah. What caused the plaintiff's change in attitude towards you? My guess is a bunch of people yes queening her privately, and then probably Lauren driving a lot of it would be my guess. Are you sure you were referring to this? Or are you sure it's not in a different, in the other filing? Declarations of, this is my lawyer. I'm an attorney admitted to practice pro hac vice. That means what spicy says. In the above caption action, I'm a partner, blah, blah, blah. So this declaration, Exhibit A is a true reply. Exhibit B, Exhibit C, Exhibit D. Okay. Exhibit A. I can't believe that. Oh my God. This has got to be copyright infringement, okay? Jesus. Did he really need to include that? The grift is so pathetic. At least it's only mentally ill losers who are throwing their money in the trash. That screenshot. Jesus. That's brutal. Exhibit B. They switched A and B in the document. Oh, okay. In acknowledging the glaring weakness of the evidence presented in support of her motion for preliminary injunction, plaintiff belatedly attempts to submit new purported evidence to establish subject matter jurisdiction where none exists. Plaintiff's motion has been fully briefed for over a month and a half. The evidentiary hearing on plaintiff's motion already occurred. Now, on the eve of the court issuing a ruling on her motion, plaintiff seeks to submit new and untimely evidence in support of her motion, depriving Bonnell of an opportunity to respond or to challenge the declarant in open court. Wait, did they file something else by Abby? Abby MC, the anonymous person, after the hearing? Or was this about what they filed like the day before the hearing? Specifically, in a last-minute attempt... Oh, I think this is the day before our hearing for the preliminary injunction. Specifically, in a last-minute attempt to establish subject matter jurisdiction, plaintiff seeks to submit a purported text message from Abby MC, wherein Abby MC claims Bonnell sent her a video of plaintiff at an unknown time. Plaintiff had every opportunity to submit such evidence with her reply brief, or at a minimum, at the evidentiary hearing on June 3rd, 2025. Plaintiff did neither. In fact, Abby MC failed altogether to appear or testify at the hearing on the motion, thereby depriving Bonnell the opportunity to cross-examine her. Even if the court were to consider plaintiff's untimely evidence, should not, the new evidence is unauthenticated, constitutes inadmissible hearsay, and fails to establish or in any way support the court having subject matter jurisdiction over this case. Pursuant to well-established federal law, the court should decline to consider plaintiff's new evidence and strike it from the record. Factual background on April 3rd, 2025. So the reason why the Abby MC thing is important is because the whole case is basically dead, except for now they brought in this person who's claiming that I sent them a video in 2023, which I maintain is not true. That person hasn't given any evidence even to this law firm, which they admitted in the hearing, but I can't show the transcript because it's being debated right now whether they're trying to get it sealed. But they admitted in the hearing that they hadn't actually seen any evidence from her that I'd actually sent her a video at all. It's literally just her saying it and whatever. The fact that they kind of submitted this as evidence literally the day before the hearing is a little bit silly because the whole point of the hearing that we had was supposed to go over the evidence for the preliminary injunction. And if they really wanted a preliminary injunction, it seems like this would have been an important thing to have like submitted earlier so that both sides could fully brief it and everything. But what are you going to do? On April 3rd, 2025, plaintiff filed a motion for temporary restraining order and preliminary injunction. On April 4th, the Honorable Jacqueline will brief it and everything. But what are you going to do? On April 3rd, 2025, plaintiff filed a motion for temporary restraining order and preliminary